ಹಲೋ ಸರ್, ಟೋಟಲ್ 16 ಇಂದ ಕೇಳಿಸ್ತಾ ಇದೆಯಾ?
ಕೇಳ್ತಾ ಇದೆ.
ಹೌದಾ? ಯಾವತ್ತು ಬಂದೇ ಇಲ್ಲ ನಿನ್ನ ಮುಂದೆ. ಏನ್ ಸ್ಟೇಜ್ ಏನ್ ಮಾಡ್ದು?
ಇದನ್ನೇನು ತೋರಿಸಿಲ್ಲ ಅವರು. ನಿನ್ನೆ ನಾವು ಅಲ್ಲಿ ರಿಟರ್ನ್ ಕೊಟ್ಟಿದ್ದು
ವಿಜಯ್ ಕುಮಾರ್ ಅವರೇ.
ಹೇಳಿ
ಸರ್, ನಿಮ್ಮ ಅಡ್ರೆಸ್ ಕಳ್ಸ್ಕೊಟ್ಬಿಡಿ. ನನ್ನ ಮೊಬೈಲ್ ಅಲ್ಲಿ ಎಂತಕ್ಕೋ ಇದು ಹೋಗ್ತಾ ಇಲ್ಲ, ಎಲ್ಲ ಡೆಲಿವರಿ ಆಗಿದೆ ಅಂತ ತೋರ್ಸುತ್ತೆ. ನಿಮ್ಗೇನಾದ್ರು ನಂದು ಆಯದು ಅಪೀಲ್ ಮೆಮೊ ಯಾವ್ದಾದ್ರು ಬಂದಿದೆಯಾ ಈಗ ಒಂದು ವಾರದೀಚೆಗೆ?
ಯಾವ ರೀತಿ ಕಳ್ಸಿದ್ರಿ?
ನಾನು ಎರಡೂ ಕಳ್ಸಿದ್ದೇನೆ, ಇಮೇಲ್ ಅಲ್ಲೂ ಕಳ್ಸಿದ್ದೇನೆ, ವಾಟ್ಸ್ಆಪ್
ನೋಡಿ. ಅದನ್ನು ಯಾವ ಕೇಸ್ ಹೇಳಿ ಅಂತ ಹೇಳ್ತಾರೆ.
ಅಲ್ಲ, ಒಂದ್ ಎರಡ ಮೂರ ಕಳ್ಸಿದ್ದೇನೆ. ನನ್ ಬಂದಿದೆಯೋ ನೋಡಿ. ನಿಮ್ದು ವಾಟ್ಸಪ್ ಅಲ್ಲೂ ಕಳ್ಸಿದ್ದೇನೆ ನೋಡಿ. ಅದನ್ನ ಎರಡರಲ್ಲೂ ಕಳ್ಸಿದ್ದೇನೆ.
ವಾಟ್ಸಪ್ ನೋಡ್ತೀನಿ ತಾಳಿ.
ಶಾಸ್ತ್ರಿ ಸರ್, ಲೈವ್ ಸ್ಟ್ರೀಮಿಂಗ್ ಅಲ್ಲಿ ಇದ್ದೀರಾ?
Wonderful.
Page wise adjournment. Page number 2. Page number 1. Serial number 1.
ಬರ್ತಾ ಇಲ್ವಲ್ಲ?
Page number serial number.
ಹಲೋ
ಮ್ಯೂಟ್ ಆಗಿಲ್ಲ ಸರ್. ಹಲೋ, ಕೇಳಿಸ್ತಾ ಇಲ್ವಾ ಸರ್? ಹಲೋ ಸರ್,
ಬರ್ತಾ ಇದೆ
ಕೇಳಿಸ್ತಾ ಇದೆ.
ಬರ್ತಾ ಇದೆ.
ಬರ್ತಾ ಇದೆ.
Page number 2, serial number 5 to 9. Page number 3, serial number 10 to 13. Page number 14 to 17. Serial number 18 to 22. Page number 23 to 26. Number 7. Serial number 27 to 35. Page number 8. Serial number 36 to 43. Page number 9. Serial number 44 to 49.
My lords, MFA number 590 of 90, my lords, 46 or 48.
Is the serial number, madam?
48, sir.
48.
My lords, your lordship may kindly grant me an adjournment.
Yes, sir. The request of council for respondent number 3. We wish this matter up to 2 weeks. Yes, what you want to say? You are appearing? Yes. We wish this matter up to 2 weeks. Secure original record.
Page number 10, serial number 15. Number 1. Etc. Respect to the respondent.
Two times, 2 weeks.
Number 15. Serial number 15. Yes.
2 weeks to comply the.
ಸರ್, ಲೈವ್ ಸ್ಟ್ರೀಮಿಂಗ್ ಅಲ್ಲಿ ಇದ್ದೀರಾ, ಡಿಸ್ಟರ್ಬೆನ್ಸ್ ಮಾಡಬೇಡಿ ಸರ್. ಮ್ಯೂಟ್ ಮಾಡ್ಕೊಳ್ಳಿ ದಯವಿಟ್ಟು.
Yes. Postal sir. Yes, serial number 19, 4 weeks. Yes.
Serial number 21 to 25.
2 weeks time is granted to comply the top subsection. Notice. Notice.
Number 2, for order, serial number 1, or serial number apparent, O Mahesh.
Yes,
Number 2, serial number 1.
Service of is taken up part. Service of notice.
Serial number 2, supervision to the apparent.
I am for appellant. My lord, question of negligence and liability is involved. I am ready, but if records
necessary.
ಬೇಕಾಗ್ತದೆ ಅನ್ನೋ ಕಾಣ್ತದೆ, ಯಾಕಂದ್ರೆ 2 ವೆಹಿಕಲ್ ಇದೆ.
Cabinet Council for the appellant has filed a memo seeking dispensation of service of notice to R1. Memo is taken on record. Service of notice to R1 is dispensed at the risk subjected to secure original record from the tribunal.
Serial number 3, supervision to the apparent, T.S. Marulai.
I am for appellant. Irali,
Yes.
My lord, doctor not examined.
Yes.
My lord, I am ready, my lord. I am ready.
Yes.
My lord,
He is ready. Yes, you make your submission.
ಇದು 1 ಲಕ್ಷ ಕಾಂಪ್ರಮೈಸ್ ಕೇಳಿದ್ದೆ, ಆಮೇಲೆ ಅವರು ಇದ್ ಮಾಡ್ಲಿಲ್ಲ. My lord,
What are the injuries?
60 years old. Date of accident 3/1/2015.
Yes.
Fracture of left tibia.
Yes.
My lord, he was inpatient for 63 days.
Yes.
Photos also produced.
Yes.
My lord, 10/22 medical bills produced.
What is
30,000.
the amount? What is the amount of the medical bill, mister?
10,722.
10,000. Yes.
30,000 ಕೊಟ್ಟಿದ್ದಾರೆ. ನಾನು 1,00,000 ಕೇಳಿದ್ದೇನೆ. It is left to the court.
Yes. Yes, yes. Doctor evidence illa. In addition, how much?
ಸ್ಯಾಟಿಸ್ಫೈ ಮಾಡಿದ್ದಾರೆ. ಅವಾರ್ಡ್ ಸ್ಯಾಟಿಸ್ಫೈ ಮಾಡಿದ್ದಾರೆ.
Yes, in addition, another 30,000.
60 ದಿನ
Not been examined. There is a
exam.
records. With interest, Mr. Shipachat.
ಒಂದು 50 ಕೊಡ್ಬೋದು. ಯಾಕಂದ್ರೆ 62 ದಿನ ಇನ್ ಮುದುಕ 60 ವರ್ಷ ಅವನು.
ಅದಕ್ಕೋಸ್ಕರನೇ.
It is left to the court.
Yes, 60. Yes, yes. We will make it 60. Yes. Tell. Shripad Shastri, Learned Counsel, appellant has filed a memo seeking dispensation of service of notice to R2. Memo is taken on record. Service of notice to R2 is dispensed at the risk of the appellant. Shripad Shastri, Learned Counsel, appearing for appellant, claimant has contended that due to the fact that the claimant has suffered grievous injury. He was inpatient for a period of 63 days. He has spent 10,722 rupees for medical expenses. The global compensation awarded by the tribunal, 30,000 is on lawyer side. Hence is not for enhancement of compensation. For contra, so Learned Counsel appearing for insurance company has contended that even though the claimant has claimed that he has suffered a grievous injury, as per the wound certificate, the injuries suffered by the claimants are minor in nature. He has not examined the doctor. Considering this injury, the tribunal has granted a just and reasonable compensation. Hence, he sought for dismissal of the appeal. Third, the Learned Counsel for the parties arose judgment and award. It is not in dispute. The claimant has suffered an injury in a road traffic accident occurred on 3/1/2015 due to rash and negligent driving of rider of motorcycle bearing registration number A41 EA 6223. Due to the accident, the claimant has suffered the following injury. He was inpatient for a period of 63 days. He has spent 10,722 rupees for medical expenses. Considering that injury suffered by the claimant, I am of the opinion that in addition to that compensation awarded by the tribunal, 30,000 has been awarded with interest. Yes. Accordingly, the appeal is disposed of. Weeks is granted to do the needful. Then weeks time. Non-compliance of the office objection, 2 weeks time is granted to comply the office.
I appear for the appellant. First respondent is the owner. I have sent a memo for dispensation of notice to the
Shri Gurudev Prasad KT, Learned Counsel, appearing for that appellant has submitted that has filed a memo seeking dispensation of service of notice to respondent number 1. Memo is taken on record. Service of notice to R1 is dispensed. What is the delay?
Other side is ready. I am ready. In case of death.
What is the delay? Is there any delay?
A delay of 44 days.
Yes, IA 1 of 2019 is filed for condonation of delay for the reason stated in the accompanying affidavit. Delay of 44 days is condoned. IA 1 of 2019 is allowed. He is not there next week.
Records, there is contributory negligence to the extent
Yes.
of 20%.
We will secure the records.
Yes.
Office is directed to secure. original records from the tribunal.
I appear for respondent number 1, my lord. In
Yes.
this case, they have not complied the order of this honorable court passed on 13/3/2020, my lord. 50% of
What is
amount
that
has to
order?
be deposited. This court has been ordered, but till date they have not deposited the amount, my lord.
Then you file an execution, mister.
I will file, sir.
Yes.
I will
See,
file execution.
interim order is subject to the deposit of 50% of the award amount. If it is
They
not
have not,
deposited,
they have not
interim
still
order will not
deposited
be
the amount.
proposed. You file an execution.
Yes, yes, my lord. I will file.
Yes. None appear for the appellant. Week's time is granted to do the needful. Yes, Muralidhar. Bernard Council for the appellant has filed a memo seeking dispensation of notice to R3. Memo is taken on record. Service of notice to R3 is dispensed at the risk of the appellant. Yes, Ranjay Gowda. Office is directed to secure original records from the tribunal.
Serial number, hearing interrogatory application matter, serial number 10, K.T. Gurudeva Prasad for appellant, M. Business Babu, W.S. Santati.
There is a delay of 46 days in filing the appeal.
Yes, delay of 46 days in filing an appeal is condoned. IA 1 of 2019 is allowed subject. Yes. Yes,
Records,
ready.
records are
Beka?
records.
Office is directed to secure original records from the tribunal.
Serial number 11, Harini Shivananda for appellant, Digambara G.S., Associate Party.
Yes, yes, madam.
I appear for the appellant, my lord. ಇದು ವೆಹಿಕಲ್ ಡ್ಯಾಮೇಜಸ್ ಗೆ ಮಾಡಿರೋದು ಕ್ವಾಂಟಮ್ ಕ್ವಶನ್ ಮಾಡಿದ್ದೇನೆ ಅಷ್ಟೇನೆ.
Ready?
ಹೌದು ಸ್ವಾಮಿ, ರೆಡಿ ಇದ್ದೀನಿ. ಅವ್ರೇನಾದ್ರು
Where is that? What is that, madam? On what ground you have challenged?
ಇದು ಕಾರು ವೆಹಿಕಲ್ ಡ್ಯಾಮೇಜಸ್ ಕೇಳಿದ್ದಾರೆ, ಇಂಜುರೀಸ್ ಕೇಳಿದ್ದಾರೆ. ಇಂಜುರೀಸ್ ನಾನೇನ್ ಸೀರಿಯಸ್ ಆಗಿ ಕ್ವಶನ್ ಮಾಡ್ತಿಲ್ಲ. 15,000 ಕೊಟ್ಟಿದ್ದಾರೆ. ಈ ವೆಹಿಕಲ್ ಡ್ಯಾಮೇಜಸ್ ಗೆ ದೇ ಹ್ಯಾವ್ ಗಿವನ್ 1,20,000 ಮಿಲಾಡ್. ಅದನ್ನ ಚಾಲೆಂಜ್ ಮಾಡಿದ್ದೀನಿ. ಇಟ್ ಇಸ್
Yes, what is, have they produced that estimated?
ಅವರು ಬರೀ ಇದನ್ನ ಹಾಗೆ ಯಾರನ್ನೇ ಎಕ್ಸಾಮಿನ್ ಮಾಡಿಲ್ಲ ಅವರು. ಬಟ್ ಸಮ್ 1,50,000 ಅಂತ ಹೇಳಿ ಇದನ್ನ ಬಿಲ್ ಹಾಕ್ತಾರೆ. ಆ ಬಿಲ್ಲುನು ಅಷ್ಟು ಅಥೆಂಟಿಕೇಟೆಡ್ ಆಗಿಲ್ಲ ಅದು.
Which is that exhibit?
ಎಕ್ಸಿಬಿಟ್ ಒಂದು ನಿಮಿಷ. ಪೇಜ್ 15 ಆಫ್ ದ ಜಡ್ಜ್ಮೆಂಟ್ ಅಲ್ಲಿ ಮೆನ್ಷನ್ ಮಾಡ್ತಾರೆ.
AME report, insurance, medical, full certificate.
ಎಕ್ಸಿಬಿಟ್ P14 ಒಂದು ರೆಸಿಪ್ಟ್ ಒಂದು ಹಾಕ್ತಾರೆ ಸ್ವಾಮಿ.
Receipt on the bill. Where is that finding regarding that, Mr. Patil, you are appearing for whom?
ಅವರು he said not an
You are only a formal party.
formal
Receipt can't require any this thing. Which is that paragraph, madam?
para 31 of the judgment.
Yes. Petitioner claiming a damages of the car of rupees 1,25,000, including the transportation of vehicle. The towing charges is 5,500. Which would mean I am the opinion that petitioner entitled for sum of rupees 1,20,000. How that exhibit P14?
ಹೌದು, ಅವ್ರು ಏನು ಬರೀ ರೆಸಿಪ್ಟ್ ಹಾಕ್ತಾರೆ ಅಷ್ಟೇನೆ. ಆ ರೆಸಿಪ್ಟುನು ಇಟ್ ಇಸ್ ನಾಟ್ ಅದು 2005 ಮಾಡೆಲ್ ಸ್ವಾಮಿ. ಕಾರ್ ಅದು ಆಲ್ಟೋ ಕಾರ್, ಅದು 2005 ಮಾಡೆಲ್. ಅದು
Whether it is
ನಮ್ಮ ಸರ್ವೇಯರ್
what is the
ಸರ್ವೇಯರ್ನ ಎಕ್ಸಾಮಿನ್ ಮಾಡಿದ್ದಾರೆ. ಆವಾಗ
what is
ಅಲ್ಲ, ಇದು ಆ ಮಾಡೆಲ್ಗೆ ಎಷ್ಟು ವ್ಯಾಲ್ಯೂ ಇದೆ ಅಂತ ಹೇಳಿ ಅದನ್ನ ಎವಿಡೆನ್ಸ್ ಮಾಡಿದ್ದಾರೆ. ಬರೀ 50 The whole vehicle itself, ಅದು ಮ್ಯಾನುಫ್ಯಾಕ್ಚರಿಂಗು ನಿಲ್ಲಿಸ್ಬಿಟ್ಟಿದ್ದಾರೆ ಇವಾಗ.
No, what is that evidence of your officer?
ಅದನ್ನ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ದೀವಿ ಸ್ವಾಮಿ.
No, what is that value of that car after depreciation?
ಅವ್ರು ಆಕ್ಚುಲ್ ಆಗಿ ಅದು ಏನು ವ್ಯಾಲ್ಯೂಯೇಷನ್ ಬರೋದಿಲ್ಲ ಅದು ಅಂತ ಹೇಳ್ತಾರೆ.
No, that cannot be. But if he is there, we could have.
ಬರೀ 55,000 ಇದೆ, ಅದೊಂದು ಹೋಲ್ ಕಾರ್ ವ್ಯಾಲ್ಯೂನೇ 55,000 ಇದೆ. ಇವರು 1,10,000 ಖರ್ಚು ಮಾಡಿದೀವಿ ಅಂತಾರೆ.
Anyhow, he is not there. We'll condone the delay and
ಆಯ್ತು
call for records.
ಆಯ್ತು.
Yes, delay is condoned. Call for records. Yes. You can condone the delay. There is a delay of 271 days in filing an appeal. IA 1 of 2021 is filed for condonation of delay. Here is that affidavit for the reason stated. Delay of 271 days, appeal is condoned. IA 1 of 2021 is allowed. For the interest for a period of 271 days. Records beka. Office is directed to secure original records from the tribunal. What about your case, Mr. You want to pay the process? You want to file a memo. Learned Counsel for the appellant in MFA 6462 of 2018 has filed a memo seeking dispensation of service of notice to R2. Memo is taken on record. Service of notice to R2 is dispensed at the risk of the appellant. Yes, office is directed to secure original records. Yes. Ready? Where is she? There is a delay of 135 days in filing an appeal. IA 1 of 2021 is filed for condonation of delay for the reason stated in the accompanying affidavit. Delay of 135 days in filing an appeal is condoned. IA 1 of 2021 is allowed. Yes. Memo for dispensation for R1 is dispensed. Delay of 183 days in filing an appeal is condoned. Not entitled for the interest. Refer this matter to Lokadala. Same. Refer this matter to delay. Dispensation R1, R3 and R4. 183 is condoned. Not entitled for the interest. At the request of the parties. Really, manager National Insurance Company, you are there. Yes, respondent number 2 is served. Party is directed to take notice. Dispensation no, condone, not entitled for the interest. Refer the Lokadala. Hello, avare memo hakidare. Yes. Dispensation for R1, R3 and R4. Delay of 183 days condoned, not entitled for the interest. At the request, refer the matter to Lokadal. Same 1, 2, 3 dispensed. 325 days delay condoned, subject to condition not entitled for the interest. Refer the at the request, refer the matter to Lokadal.
My lord, I represent for Kamala DK. There are 3 more appeals filed by the claimant, it seems, my lord. 26 of 20, 27 of 20, and 29 of 20 have to be connected and posted together.
Yes, Learned Counsel for the appellant has submitted that. This appeal may be called along with the zones.
Madam, 26, 27
And 29.
of 2020.
How, sir? How?
Serial number 19. Our petitioner for appellant Ravish Bindi, Ashok Party.
Yes, Mr. Session. Ready? ಕಟ್ಸ್ಬೇಕಾ ಎಷ್ಟು ಕೊಟ್ಟಿದ್ದಾರೆ ಹಾ ಆಯ್ತಲ್ಲ ಅದೆಲ್ಲ ಹತ್ರ ಕೂತ್ಕೊಂಡು ಸೆಟ್ಲ್ ಮಾಡಿ. ವೈ 3 lakhs ಕೊಟ್ಟಿದ್ದಾರಾ? No, why that the court has reduced? Other limb? No, it is a limb. No, he has assessed for limb. Where is that? Where is that discussion? Education about that petitioner document reveals that petitioner sustained grievous injury has taken a treatment patient 15 days. X-ray 22-degree fracture tumor oral. Yes, mister. Globally, apex court of the High Court disabilities. Yes, though the doctor has expressed about 28% disability to the petitioner, it may reduce. Doctor, whether he said that you have that evidence of doctor, mister? What are the injuries? What is your age? Huh? Minor. Yes, if it is more than 10% under 3 lakhs. Yes, we'll secure the. No, as he assessed each this thing. Mother, no, how can we assess the whole body without assessing the limb? Or he has to assess. Yes, we'll get the records. Office is directed. We'll see the twin certificate. Huh? Yes. Office is directed to secure original records from the tribunal. Office is directed to delete the name of Ashok and Patil for respondent. Number 2. Delay of 116 days in filing an appeal is condoned. At the request, refer to the matter. No, all officers let us. Yes. When he is requested, we'll refer it. Yes. Let us see if it is not this thing, it will come back. Yes. Refer to Loka Adalat. Yes.
Is it 21, my lord?
Yes.
Is it 21, my lord?
There is a delay of 89 days in filing an appeal is condoned. IA 1 of 2019 is allowed. Memo for dispensation of notice to R1 is dispensed. At the request of the counsel for the appellant, refer this matter to Loka Adalat. Yes, Mr. Purna.
I am for the first respondent, my lord. Ali, you amendment ಮಾಡ್ಕೊಂಡ್ಬಿಡ್ಲಿ. When it is specifically shown as new national insurance company, insofar as third respondent is concerned, the matter may be disposed of. ಇವತ್ತೇ ಬೇಕಾದ್ರೂ ಮಾಡಬಹುದು, but amendment ಆಗೋಗ್ಬಿಟ್ರೆ my ವಕಾಲತ್ may be confined to first respondent only. Purna Bodra's wakalat is confined to first respondent.
You are no, first respondent is the New India only.
Eradu kade India
Wait.
Oh, yes. For first respondent.
Wait. Purna Bhadrarao, you wait. Adrallo kuda New India Insurance Course. You want to amend it? Yes, you are appearing for. You have already filed an wakalat. Yes. No, you have filed an wakalat as in a national insurance company. National. Then you amend it. Yes. IA 1 of 2022 is filed for amendment of cost title for the reason stated in the accompanying affidavit. IA 1 of 2022 is allowed. Appellant is learned counsel for the appellant is permitted to amend the cost title. Yes, what is this matter? Yes. Amend it.
For my wakalat may be confined to first respondent.
First respondent ಗೆ ಇರೋದು ಬಿಡಿ. Yes. Ashok and Patil.
Three ಅಂತ ತೋರಿಸಿದ್ರು ಅದಕ್ಕೆ ನಾನು 3 ಅಂತ ಮೆನ್ಷನ್ ಮಾಡಿದ್ದೆ, ಬಟ್ ಇಟ್ ಮಸ್ಟ್ confined to only first respondent.
Yes.
ಮಾಡಿದ್ದಾರೆ ಸರ್, ಮಾಡಿದ್ದಾರೆ.
Publishing a PF issue notice to R2 and R3. Yes, learned counsel for the appellant has filed a memo seeking dispensation of service of notice to R2 and R3. Notice to R2 and R3 is dispensed at the risk of the appellant. IA 1 of 20 is dismissed as not pressed. Yes, madam, what is this? No, we'll admit it because the respondent is served unrepresented. Only quantum. Yes. Heard. Admit. Yes. Yes.
My lord, I am for the respondent number 6, my lord.
Yes.
8, respondent number 8.
Respondent number 8. Yes. Learned counsel for the appellant has filed a memo seeking leave of this court to withdraw this appeal. Memo is taken on record. The above appeal is dismissed as withdrawn. Yes. Who is Krishnaswamy is appearing. Office is directed to delete the name of P. Pradeep for R6. Yes, Mr. Office is directed to refund that statutory amount in favor of the appellant after due verification. Owner appeal, Yes.
Vijay Kumar.
My lord, this appeal by the APSRC, my lord, challenging negligence and quantum of compensation. I am ready to deposit 50% of the award amount before the High Court.
IA 1 of 2022 is dismissed as not pressed. Heard. Issue notice. Stay of judgment and award dated 16th August 2021, passed by MEACT Bangalore in MEC 192 of 2018. Subject to condition, appellant has to deposit 50% of the award amount with interest before the tribunal within 4 weeks from today.
My lord, one submit. My lord, this matter is connected with MFA 6082/21.
Sir, number
6082/21. 608. And my lord,
Who has appeared in that?
NR Rangegowda.
Which respondent?
The respondent, only respondent.
Only respondent, yes. Adralli NR Rangegowda is directed to take notice for respondent. Stay of zones.
Much obliged.
Release this matter along with the zones.
serial number 25, BC Shivanya Gowda.
IA 1 of 2022 is dismissed as not pressed. Heard learned counsel for the appellant for the reason stated in the accompanying affidavit. heard the learned counsel for the appellant. Stay of judgment and award dated 9th February 2022, passed by MESCT Tumkur in MEC 189 of 2019, subject to deposit 50% of the award amount with interest in 4 weeks from before tribunal. Same. Is it connected? Then on what ground you are challenging this? Yes. IA 1 of 2022 is dismissed as not trust or issue notice. Stay of judgment and award dated 17th March 2022, passed by MESCT Bangalore in MEC 7533 of 2018, subject to appellant deposit 50% of the award amount with interest within 4 weeks from today before the tribunal. Yes, yes. Yes, Kalyan. None appear. Release this matter up to 4 weeks. No, if he is not come, what to do? Therefore, I adjourned that 4 weeks because I am last occasion also same thing is happened. If the claimant advocates are not interested, why that insurance company advocates has to be worried? Let them take it their own time. Yes. Yes. Ready. Yes. Yes. 2017. Yes. Yes. Where is the discussion of the doctor? No, this paragraph 17. Yes. Now, doctor said, though the doctor has stated 40% of, yes, tribunal has taken 1/3 ಎಷ್ಟು ಮಾಡಿದ್ದಾರೆ? Yes, ಅದು correct ಇದೆ. Income has to be, yes. How much it is awarded? Pain and suffering 20,000 has been awarded. Attendance, conveniences, loss of income during the later period 3 months they have given. Loss of earning due to the disability, amenities. What is that interest awarded? 8%. Yes, third. Attendance, convenience charges 10,000 ಕೊಟ್ಟಿದ್ದಾರೆ. Yes. Yes, we will consider. Yes, Srimati Sarita Kulkarni, learned counsel appearing for the claimant has contended that at the time of the accident, claimant was earning 15,000 per month. The tribunal has considered notional income of the claimant as 9,000 per month is on lower side. She further contended that due to the accident, the claimant has suffered grievous injury. He was inpatient for a period of 13 days. He has suffered a lot of pain during the treatment. He has to suffer this disability and unhappiness throughout his life. The compensation awarded by the tribunal for pain and suffering, loss of amenities, other incidental expenses is on lower side. Hence, he sought for enhancement of compensation. For contra, B. Pradeep, learned counsel appearing for insurance company, has contended that even though the claimant has claimed that he was earning 15,000 per month, he has not produced any document to establish the same. Therefore, the tribunal has rightly assessed the notional income of the claimant as 9,000 per month. He further contended that considering that evidence of doctor, considering that wound certificate, exhibit P5, the overall compensation awarded by the tribunal is just and reasonable. Hence, he sought for just and reasonable. Lastly, he has contended that the interest awarded by the tribunal, 8% is on higher side. Hence, he sought for dismissal of the appeal. Heard the learned counsel for the parties, arose judgment and award. It is not in dispute the claimant has suffered an injury in a road traffic accident occurred on 27/12/2017 due to rash and negligent driving of driver of Maruti Alto car bearing registration number KA01 MG 8678. Due to that accident, the claimant has suffered the following injury. The tribunal, after considering the evidence of doctor, has right to assess the whole body disabilities as 13%. Even though the claimant has claimed that he was earning 15,000 per month, he has not produced any document to establish the same. Under those circumstances, the notional income has to be assessed as per the guidelines issued by Karnataka Legal Service Authority. For the accident occurring 2017, the notional income has to be considered as 11,000. At the time of the accident, he was aged about 60 years. The multiplier applicable to the age group is 7. Accordingly, loss of future earning has been reassessed 60. 609. What is his age? 64. Tribunal has taken, yes. He was aged about 64. The multiplier applicable to that age group is 7. Accordingly, the loss of income due to that loss of future earning has been reassessed as follows. Aadhaar card and other documents reveals that he is born on 1/1/1954. That is the finding of the tribunal. Therefore, 1/1/1954 andre, what is the date of the accident? 2017. Yes, 64. See, after 60, if we take any distinct decision, yes, it will not make any difference. Due to that accident, the claimant has suffered the following injury. He was inpatient for a period of 13 days. He has suffered a lot of pain during the treatment. He has to suffer this disability and unhappiness throughout his life. Considering that evidence of doctor, considering that injury suffered by the claimant, I am of the opinion that the claimant is entitled. I am inclined to enhance compensation for pain and suffering from 20,000 to 50,000. Loss of immunities from 10,000 to 40,000. Loss of income during the later period has to be granted for 3 months. The attendance conveyance charges has to be enhanced from 10,000 to 15,000. Accordingly, the enhanced compensation amount carries 6% interest. Accordingly, the appeal is allowed in part. Judgment and award passed by the tribunal is modified as follows.
My lord, I am for the respondent, my lord. This
Yes.
matter can be disposed of.
Yes, ready, Rangeಗೌಡ್ರು.
Yes, my lord. ಅಲ್ಲ ಇದರಲ್ಲಿ ನಾವು ಮಾತಾಡ್ಕೊಂಡಿದ್ದು 4 lakh rupees ಲಂಸಮ್ ಅಂತ. ಸೊ ತಾವು ಒಂದು ಜುಡಿಷಿಯಲ್ ಆರ್ಡರ್ ಬರೆದ್ರೆ ಸೊ 11,000 ನೋಷನಲ್ ಇನ್ಕಮ್ into 12
Yes.
into 18 into 13%. 3,08,000 ಆಗುತ್ತೆ. ಪ್ಲಸ್ ಇಂಟ್ರೆಸ್ಟ್ ಮಾಡಿದ್ರೆ ಅಲ್ಲಿಗೆ ಬರುತ್ತೆ. ಅಂಡ್ ಅದರ್ ಹೆಡ್ಸ್ ಜಸ್ಟ್ ಆನ್ ರೀಸನ್ ಯಾಕೆಂದ್ರೆ 1 lakh ಫಾರ್ ಸಿಂಗಲ್ ಫ್ರಾಕ್ಚರ್ಗೆ 1 lakh rupees ಕೊಟ್ಬಿಟ್ಟಿದ್ದಾರೆ ವಿತೌಟ್ ಕನ್ಸಿಡರಿಂಗ್ ಫ್ಯೂಚರ್ ಪ್ರಾಸ್ಪೆಕ್ಟ್ ಇದು ಲಾಸ್ ಆಫ್ ಇನ್ಕಮ್. ಮೋಸ್ಟ್ಲಿ ಅದು ತುಂಬಾ ಜಾಸ್ತಿ ಎಲ್ಲ ಕವರ್ ಆಗಿ ಅದೆಲ್ಲ ಕವರ್ ಆಗ್ಬಿಟ್ಟಿದೆ ಅದರಲ್ಲಿ ಸಿಂಗಲ್ ಫ್ರಾಕ್ಚರ್. ಮಲಡ್ ಪ್ಯಾರಾ 32 you last may kindly see ಮಲಡ್. ಸಾರಿ ಪ್ಯಾರಾ
all other
23
ಎಷ್ಟು ಕೊಟ್ಟಿದ್ದಾರೆ ಪ್ಯಾರಾ
23 you last may kindly see the injury. Next page ಅಲ್ಲಿ
yes
deep lacerated injury over the right knee measuring 20 into 6 centimeter. Lacerated wound over the chin 6 into 4 centimeter. Abrasion 2 into 3 centimeter on the right cheek. ಅದು ಬಂದು ಕಾಂಪೌಂಡ್ ಫ್ರಾಕ್ಚರ್ ಆಫ್ ಟಿಬಿಯಾ ಅಷ್ಟೇ. ಇಟ್ ಇಸ್ ಓನ್ಲಿ ಫ್ರಾಕ್ಚರ್ ಆಫ್ ಟಿಬಿಯಾ. ಟ್ರಿಬ್ಯುನಲ್ has already ordered total compensation of rupees
2,96,000.
ಈಗ 3,06,000 ಪ್ಲಸ್ ಇಂಟ್ರೆಸ್ಟ್ ಆದ್ರೆ ಜಸ್ಟ್ ಆನ್ ರೀಸನಬಲ್. ಯಾಕೆಂದ್ರೆ ಪೇನ್ ಅಂಡ್ ಸಫರಿಂಗ್ 1 lakh ಕೊಟ್ಬಿಟ್ಟಿದ್ದಾರೆ ಫಾರ್ ಸಿಂಗಲ್ ಫ್ರಾಕ್ಚರ್ಗೆ. ದಟ್ ಬಿಕಾಸ್ ದ ಟ್ರಿಬ್ಯುನಲ್ ಇಸ್ ನಾಟ್ ಗೋಯಿಂಗ್ ಟು ಗ್ರಾಂಟ್ ಎನಿ ಕಂಪನ್ಸೇಷನ್ ಫಾರ್ ಫ್ಯೂಚರ್ ಲಾಸ್ ಆಫ್ ಇನ್ಕಮ್. ಅದೆಲ್ಲ ಉಳಿದೆಲ್ಲ ಕವರ್ ಆಗುತ್ತೆ.
See, pain and suffering 40, amenities 40, 80, 20 for other head. 1 lakh ರೂಪಾಯಿ ಅಲ್ಲೇ ಸೇರಿಸ್ಕೊಟ್ಟಿದ್ದಾರೆ. ಅಟೆಂಡೆನ್ಸ್ ಚಾರ್ಜಸ್ ಕೊಟ್ಟಿದ್ದಾರೆ. ಲಾಸ್ ಆಫ್ ಇನ್ಕಮ್ ಡ್ಯೂರಿಂಗ್ ದ ಲೇಬರ್ ಇಲ್ಲಿ 20 ತಗೊಂಡ್ರೆ ಇಲ್ಲಿ 10. Saying that in only thing is that loss of future earning.
11,000 into 12 into 18 into 13%. 3,08,000 plus interest.
No, he is saying that 14% disability, Mr. Vijay Kumar.
ಆಗ್ಬೋದು ಸ್ವಾಮಿ, ತಗೊಳ್ಳಿ ಸ್ವಾಮಿ, ತಗೊಳ್ಳಿ.
Angegowda NR Learned Council climate has contended that to the extent the climate has suffered previous injury, he was inpatient for a period of 53 days. For earning 20,000 per he has examined the doctor. Doctor has assessed disability of 40%, 54%. The tribunal has not considered loss of future earning. He further contended that the tribunal is also failed to grant any compensation for loss of income during the labor period. Sought for enhancement of compensation. For contra, Vijay Kumar, Karnataka Council appealing for insurance company is contended that injuries suffered by the claimant are minor in nature. The tribunal has awarded 1 lakh rupees for pain and suffering is an example. Considering that injury, considering his age and avocation, the overall compensation awarded by the tribunal is sought for dismissal of law. Ordered the Learned Council for the parties. Thereof judgment and award. It is not in dispute that claimant has suffered an injury in a road traffic accident occurred on 17/9/2017 due to rash and negligent driving of driver of tractor trailer bearing registration number KA16 PA 6755-6757. Due to that extent, the claimant has suffered the following injury. He has examined Dr. Venkata Shiva Reddy as PW2. In his evidence, he has deposed that the claimant has suffered 44% disability to particular limb. Due to that disability, he is unable to do his day-to-day work. Therefore, the claimant is entitled for loss of income during the later period. If whole body disabilities has to be assessed, considering that evidence of doctor and considering that wound certificate exhibit. Which is that exhibit wound certificate?
Exhibit P.
Exhibit P6. I am of the opinion that the whole body disabilities can be assessed 14%. Even though the claimant is claimed that he was earning 20,000 per month, he has not produced any document to establish the same. The notional income has to be assessed as per the guidelines issued by Karnataka Legal Service Authority. For the accident occurred in 2017, the notional income has to be considered as 11,000. At the time of the accident, he was aged about 25.
25.
Applicable to the age group is 18. Accordingly, loss of future earning has been reassessed as follows. In respect of compensation awarded by the tribunal in the other hand are just and reasonable. Accordingly, the appeal is allowed in part. Judgment and award passed by the tribunal is modified as follows. The enhanced compensation amounts carry 6% interest.
Much obliged.
Yes, madam. Records necessary. Office is directed to secure original records from the tribunal.
I appear for the appellate counsel to see go through the records. You will ask me call this matter on Monday or Tuesday. By the time
It's a case of death, we'll see. Now, if there is no dispute in respect of the income, in other aspects, it is covered by Supreme Court judgment.
No, my lord, in respect of the income, my lord, I want to rely upon.
ಹೂವಿನ ಹಡಗಲ್ಲಿ ಬೆಳಗ್ಗೆ 50,000 ರೂಪಾಯಿ ವರಮಾನ ಹೊಂದಿದ್ದು ವೃತ್ತನ ತಂದೆ ವಿದ್ಯಾವಂತನಾಗಿದ್ದು ವ್ಯಾಪಾರದಲ್ಲಿ ಅನುಭವವಾಗಿದ್ದು Tribunal has taken what is that income?
Was a graduate, my lord.
ಇದು ಎಂತದು ಅಂತಂದ್ರೆ future prospects has been added. What is his age? 29 years. 40%. What is the date of the accident? 16, 9,500. 40%.
ಇದರಲ್ಲಿ 9,000
40%. Plus 40%. Plus divided by 50%. What is the multiplier? 17. 17,
17.
17.
How?
56,600 plus 30. Plus 80. 14,66,600. 14,66,600. 13,56,600 plus 30 plus no, he's a bachelor.
Bachelor, my lord. I agree, my lord. But
Tribunal has taken 1/3. No, tribunal has taken 1/3. No, if it is recalculated, it will reduce. He wants time. We'll see. Yes,
Lord, I
income.
will come and tell.
Otherwise, it will come down.
Right.
Yes, when do you want?
Monday or Tuesday, my lord.
Records ಬಂದಿದ್ಯಾ? Yes, at the request of counsel for the appellant, release this matter next week.
One day.
No,
ಗುರುವಾರ
50% ಮಾಡಿ, we'll see that what is the income can be taken.
ಅಲ್ಲ ಬುಧವಾರ ಅಥವಾ ಗುರುವಾರ ತಾವು ಫ್ರೈಡೆ ಅಂದ್ರೆ ಮತ್ತೆ ಪ್ರಾಬ್ಲಮ್.
Thursday.
ಹಾಫ್ ಡೇ ಇರ್ತದೆ. Please.
Thursday. No. Only today is half day, Mr. Not all
No,
Friday is
avatu-
half day. All Sunday.
ಫ್ರೈಡೆ ಏನಾದ್ರು
All Sunday is holiday, but all Friday is not half day. Yes.
ಇಲ್ಲ, ಅವತ್ತು ಏನಾದ್ರು ಬ್ರೇಕ್ ಆದ್ರೆ ಅಷ್ಟೇ.
Yes. Thursday.
Please.
Yes. 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 No, first case, it is for the damages to the vehicle. And then, yes, when do you? Thursday. Wednesday, yes, 6th. What is this? $2,000? 7,500. Yes, so what is your claim? The petition. Oh, what is the claim? The business earning 50,000 per month. 2016. 9,500. What is the disability, Mr.? Yes, 50%. There is no dispute regarding that. Only income has to be enhanced. Other head ಅಲ್ಲಿ pain and suffering ಸ್ವಲ್ಪ ಜಾಸ್ತಿ ಮಾಡಬೇಕು. Medical expenses as given, food and nourishment, attendance charges, loss of income during the later period. How many days you are in the hospital? 8 days. 2 months. Future earning has to reassess. Loss of immunities 20,000. What is that interest? %6%. That's all. Right. There is no dispute regarding the disability, the liability. 1 and 2 are directed. Sri Patil Karegowda, Learned Counsel appearing for the claimant has contended that at the time of the accident, the claimant was aged about 24 years, working as a driver and also doing in a transport business, earning 50,000 per month. The tribunal has assessed notional income of the claimant as 7,500 is on lower side. He further contended that due to that extent, the claimant has suffered previous injury. He was inpatient for a period of 6 to 8 days. He has suffered lot of pain during the treatment. He has to suffer this disability and unhappiness throughout his life. The compensation awarded by the tribunal for pain and suffering, loss of immunities, other incidental expenses is on lower side. Hence, he sought for enhancement of compensation. For contra, Shri O. Mahesh, Learned Counsel appearing for insurance company has contended that even though the claimant has claimed that he was earning 50,000 per month, he has not produced any document to establish the same. Therefore, the tribunal has rightly assessed the notional income of the claimant as 7,500. He further contended that considering that evidence of doctor, considering that injury suffered by the claimant, the compensation awarded by the tribunal for pain and suffering, loss of immunities, other incidental expenses is just and reasonable. Hence, he sought for Dismissal of the appeal. Heard the learned counsel for the parties. Arose judgment and award. It is not in dispute. The claimant has suffered an injury in a road traffic accident occurred on 10/11/2016 due to rash and negligent driving of driver of car bearing registration number KA02 F2950. Due to that accident, the claimant has suffered the following injury. He was inpatient for a period of 8 days. Considering that evidence of the doctor, the tribunal has rightly assessed whole body disabilities is 10%. Even though the claimant is claimed that he was earning 50,000 per month, he has not produced any document to establish the same. Therefore, notional income has to be assessed as per the guidelines issued by Karnataka Legal Service Authority. For the accident occurred in 2016, the notional income has to be considered as 9,500. At the time of the accident, he was aged about 24 years. The multiplier applicable to the age group is 18. Accordingly, loss of future earning has been reassessed as follows. Due to that extent, the claimant has suffered the aforesaid injury. He was inpatient for a period of 8 days. He has suffered a lot of pain during the treatment. He has to suffer this disability and unhappiness throughout his life. Considering that evidence of doctor, considering that injury suffered by the claimant, I am inclined to enhance the compensation for pain and suffering from 20,000 to 40,000. Loss of immunities from 20,000 to 40,000. Loss of income during the later period has to be granted for 2 months. The compensation awarded by the tribunal in the other hand are just and reasonable. Accordingly, the appeal is allowed in part. Judgment and award passed by the tribunal. In view of order dated 22/2/2022, the claimant is not entitled for the interest for a period of 140 days.
I appear for appellant.
Ready? Connected in. Yes.
This is in respect of MEC 137 of 2017.
Yes.
Ink page 23. Discussion
Yes.
has been made.
Yes.
He was aged about 28 years. He was doing driving work and also photographer. And he
Yes.
has claimed 25,000 per month.
Yes.
The doctor has assessed the disability at 35% to whole body. But MACT has taken 25% disability and income has taken at 7,000 per month.
Yes.
His fourth toe of left leg has been auto amputated.
Whole body is taken 30%.
25%, it has MACT has taken 25%.
Where is that? Which paragraph it start regarding this discussion?
Ink page 23, para 35.
Para 35. 137.
137 MSc.
Yes, 35. Yes. What is the income tribunal has considered?
7,000.
7,000.
He was a driver. A DL has been produced and marketed at exhibit P25.
Yes. But
And,
was working in a driver and also photographer earning 25,000 per month. He has not placed any evidence to substantiate his income. Accident has occurred 2016. Yes. Yes. The calculated total disability of whole body is 35%. Stability is. No, he has not discussed how much doctor has said regarding the disability.
Yes, he has taken one injury. His reasoning In view of the same, the disability deposed as far as stability component has to be taken for one injury.
No, where is that evidence of doctor? Records
Yes.
idea. We'll secure the records because he has not discussed. What is that limb? Office is direct.
ಎರಡು ಲೋಯರ್ ಲಿಂಬು ಮತ್ತೆ ಅಪ್ಪರ್ ಲಿಂಬ್ ಎರಡಕ್ಕೂ ಇದ್ ಮಾಡಿ ಆ ತರ ಮಾಡಿದ್ದಾರೆ ಹೋಲ್ ಬಾಡಿಗೆ.
Office is directed to secure original records from the tribunal post immediately after receipt of the records. Delay of 164 days in filing an appeal is condoned. IA 1 of 2002 of 19 is allowed subject to condition not entitled for the interest. Yes. Yes. Manjunath. Office is directed to secure original records from the tribunal. Yes, Mr. Ah, 86. On the judgment and the he can't say anything more than that. Yes. For counter Leonard Council incident from the deceased as found, sir. Malaya died in the accident 90 years at the time of the accident, even though the claimant claimed that this was running 50,000 per month. So on, sir. Yes. 10,000 income should be taken notionally. Yes. Yes. That is the only point. What is that income you have claimed? 10,000. What is the date of the accident? 17. Yesterday. 17 in 9,000. 11,000. 10,000 has to be taken because your claim itself 10,000. Yes. Security guard earning 10,000 per month contributed to the entire amount of the maintenance of the family due to the so and so. PNPC. What is his age? 5. Then what is the deduction by the tribunal? 50%. Sons are there? Yes. Transport, medical. Consortium waste ಕೊಟ್ಟಿದ್ದಾರೆ. Yes. That's all, Mr. Yes, we'll consider your objection. Yes. Since he is he claimed that he is working as a security guard. I 50% madam, 10,000 ton. Yes. So and so, learned counsel appearing for claimant has contended that at the time of the accident, deceased was working as a security guard and earning 10,000 per month. The tribunal has assessed notional income of the claimant as 6,000 is on lower side. He further contended that there are 4 dependents. Their claims that they are entirely depending upon the income of the deceased. The tribunal has deducted 50% of the income of the deceased instead of deducting 1/3 for personal expenses. Lastly, he has contended that in view of judgment of apex court in case of magma, the claimants are entitled 40,000 each. Hence, he sought for enhancement of compensation. Per contra, Shri Daballi, Learned Counsel appearing for Insurance Corporation. Corporation has contended that even though the claimant has claimed that he was earning 10,000 per month as a security guard, he has not produced any document to establish the same, and he was aged about 80 years. Therefore, the tribunal has rightly assessed the notional income of the deceased as 6,000 per month. He further contended that the wife of the deceased is aged about 70 years. The respondent number 2, the claimant number 2, 3, and 4 are the major sons. Daughter, Allah. Respondent number 3 and 4 are the married son. Allah. The claimant number 3 and 4 are the sons of the deceased. They are major and they are not depending upon the income of the deceased. And therefore, and the claimant number 2 is married daughter. Considering his age and considering that there are a major sons, the tribunal has rightly deducted 50% of the income of the deceased for personal expenses. Therefore, he contended that considering his age and avocation, the tribunal is justifying granting, the tribunal has granted a just and reasonable compensation. Lastly, he has contended that the interest awarded by the tribunal, 8% is on higher side. Hence, he sought for, yes, Mr. W. That is there, you have not challenged anything. Finding of the tribunal, you cannot, there is no appeal from your side. Yes. Hence, he sought for dismissal of the appeal. Heard the learned counsel for the parties. Feroz, judgment and award. It is not in dispute. Giriyappa died in road traffic accident occurred on 27/6/2017 due to rash and negligent driving of driver of BMTC bus bearing registration number KA 57 F0777. At the time of the accident, deceased was aged about 80 years. It was claimed that he was earning 10,000 per month as a security guard. Even as per the Loka Adalat chart, the notional income for the accident occurred in 2017 is 11,000. Therefore, the monthly income of the deceased can be assessed 10,000 per month. The first claimant is aged about 70 years. The claimant number 3 and 4 are the major sons. They have their own sources of income. And claimant number 2 as married daughter. Considering the same, I am of the opinion that the tribunal is justifying deducting 50% of the income of the deceased for personal expenses. The multiplier applicable to the age group is 5. Accordingly, loss of future earning, loss of dependency has been reassessed as follows. In addition, 15,000 for loss of estate, 15,000 for funeral expenses. In view of judgment of apex court in case of Magma, the first claimant is entitled 40,000 for the spousal consortium. 2, 3, and 4 are entitled 40,000 each for parental consortium. The enhanced compensation amount carries 6% interest. Accordingly, the appeal is allowed in part. Judgment and award passed by the tribunal is modified as follows. In view of order dated 21/4/2022. The claimant is not entitled for the interest for a period of 420 days.
Serial number 38.
Yes. At the request of counsel for respondent number 2, release this matter after 2 weeks. Yes, madam, ready. Office is directed to secure original records from the tribunal. Yes, mister. Two insurance company. Yeah, Nibrumela liability. Yes. Yes. Driver 15,000. Yes. 10,000. What is that? 2017? 11,000. Future prospects tandidara? Kotilva? 22 years under 40%. Who are the claimants, mister? 50%. Bachelor. Parents. ಯಾರೋ ಒಬ್ಬರೇ ಇದ್ದಾರಲ್ಲ, ಯಾವ್ದಿದು? MEC ನಂಬರ್ ಯಾವ್ದೋ ಕೊಟ್ಟಿದ್ರಲ್ಲ ಬೇರೆ. ಸುರೇಶ್ ಅನ್ಲಾಕರ್. Yes. First claimant is that father and mother. Second, the third is brother is not entitled, major. That's all. 50-50 ಮಾಡಿದಾರಾ? ಇಂಟ್ರೆಸ್ಟ್ ಎಷ್ಟು ಕೊಟ್ಟಿದ್ದಾರೆ ಮಿಸ್ಟರ್? Shri Satish T, Bernard Council appearing for the claimant has contended that at the time of the accident, deceased was earning 15,000 per month as a driver. The tribunal has assessed the notional income of the deceased as 10,000 per month is on lower side. He further contended that in view of judgment of apex court in case of Pranay Sethi, 40% of the income of the deceased has to be added for future prospects. Lastly, he has contended that in view of judgment of apex court in case of Magma, the claimants are entitled 40,000 each, hence he sought for enhancement of compensation. Per contra, Shri B. Pradeep and M. Venkatesh, learned counsel appearing for insurance company, has contended that even though the claimant is claimed that deceased was earning 15,000 per month, they have not produced any document to establish the same. Therefore, the tribunal has rightly assessed the notional income of the deceased as 10,000 per month. They further contended that since the claimant has failed to establish their income, the tribunal rightly has not considered that future prospects. Lastly, they have contended that considering that age and avocation of the deceased, the overall compensation awarded by the tribunal is just and reasonable. Hence, they sought for dismissal of the appeal. Heard the learned counsel for the parties. There was judgment and award. It is not in dispute. Pradeep Kumar died in road. Chetan Kumar died in road traffic accident occurred on 28/1/2017 due to rash and negligent driving of driver of lorry bearing registration number KA 40 A2508. Even though the claimant has claimed that deceased was earning 15,000 per month as a driver, they have not produced any document to establish the same. Therefore, the notional income has to be assessed as per the guidelines issued by Karnataka Legal Service Authority. For the accident occurring 2017, the notional income has to be considered as 11,000. In view of judgment of apex court in case of Pranay Sethi, 40% of the income of the deceased has to be added for future prospects. Since he was in a since deceased was in a bachelor, the 50% of the income of the deceased has to be deducted for personal expenses. At the time of the accident, he was aged about 22 years. The multiplier applicable to that age group is 18. Accordingly, loss of dependency has been reassessed as follows. In addition, 15,000 for loss of estate, 15,000 for funeral expenses. In view of judgment of apex court in case of Agma, the first claimant is entitled, the claimant number 1 and 2 are entitled 40,000 each for filial consortium. Accordingly, the appeal is allowed in part. Judgment and award passed by the tribunal is modified as follows. Brother, a major, he is not entitled. Yes, Srinivas. Yes, right. Yes. But pillion rider is entitled 163A. Yes. Yes, Mr. What is the finding of the tribunal? No, finding. What is the finding of the tribunal, Mr. Pillion rider. Yes. Then that finding is not challenged by. Yes. Yes. Arrow number? It is not in dispute that the insurance company of the offending bike was in force on a date of accident. However, specific defense of the owner is that liability of the respondent company is of towards the third party only. The owner of the offending vehicle cannot third party. Advocate of the petitioner in this regard has placed a reliance on judgment of transport MFA. So on, so it is necessary to notify. No, paragraph 15, where it is said that finding of the tribunal. Petitioner has examined witness. Is it a case of injury? A brief case of the petitioner that on once when the petitioner as a pillion rider along with the rider was going in the motorbike so and so. To prove is the claim petitioner had not examined himself and he has not examined his own. Whether the petitioner proved that he has sustained injury in the accident occur and so on. Yes, during the course of loan deposit. Complaint given to the petitioner instance as investigated of investigated case further investigation. For counter, the respondent did not approve its case part observing the petitioner's also during the course of evidence. She has reiterated all the contention. Extra. Denied this liability to pay the compensation as denied that liability for that respondent is the insurer of the offending bike. However, petitioner himself is the owner, RC owner of the offending bike. Stood that the insurance policy of this bike was according 163 judgment. See, they have so the tribunal has followed the judgment under 166, 163A. That third party concept will not arise as at all. See, notwithstanding anything contained in that other provisions of the act, that means to say other provision 177 and all not applicable for 163A. Even if it is he himself was driving, and also some extent Supreme Court said, but we are not considering. But he was driving. What is that? ಎಷ್ಟದು ಅಲ್ಲ ಪಿ ಎ ಕವರೇಜ್ ಎಷ್ಟಿದೆ 1 ಲಕ್ಷ. ಅಲ್ಲ then I think even then ಇದಕ್ಕಿಂತ ಜಾಸ್ತಿ ಅದರಲ್ಲೇ ಬರುತ್ತೆ ಅಂತ ಕಾಣಿಸುತ್ತೆ. 163A ಕೆಳಗಡೆ what is that? He will get 1 lakh. Yes, Chandrakant Tiwari, Supreme Court has held. Yes, that's all. We'll send it back. Yes. Or if you are agreed that 1 lakh will force it, because PA coverage is there. Yes, even then he is entitled. I let the tribunal decide what is that injury, how much it cost. Even otherwise, you are also entitled under that. That will also make an observation. Srinivas V. Learned Counsel appearing for the claimant has contended that the claim petition was filed under section 163A of the Motor Vehicles Act. The claimant was proceeding as a pillion rider. He has suffered an injury. The claim petition is maintainable. The insurance company is liable to pay that compensation. The tribunal is error in held that he cannot claim compensation against his insured. In support of his contention, he has relied on judgment of Apex Court in case of Chandrakant Tiwari versus New India Assurance Company Limited and others, reported in 2027 SEC 386. He further contended that even assuming that, even for the sake of the argument, assuming that the claimant was riding that motorcycle, as per the policy he has paid PA coverage and additional premium of 50 has been collected. The tribunal has not considered this aspect of the matter. Hence, he sought for allowing that appeal. Per contra, Sri Sanmati, Learned Counsel appearing for insurance company, has contended that the claimant himself was riding that motorcycle. He fell down from motorcycle and suffered an injury, and it is in a self fall, and he himself is an insured. ಹೌದು ಅದನ್ನೇ ಹೇಳ್ತಾ ಇರೋದು. 63 I have not said this. He said self fall and he cannot claim compensation against his insurer. The tribunal has rightly rejected the claim petition. Hence, he sought for allowing the dismissal of the appeal. Heard the learned counsel for the parties, Feroz, judgment and award. The claimant has filed a claim petition under section 163A of the Motor Vehicles Act. The specific case of the claimant is that on 23/12/2015 at 4 p.m. he was proceeding as a pillion rider in a bike bearing registration number KA 46J1273. Due to in a RB Steels BM Road, in front of RB Steels BM Road, Yavur Sakleshpura, the rider of the bike has rode the same in rash and negligent manner by overtaking the car. He dashed that divider. Due to that impact, the claimant fell down and suffered injury. The claim petition is filed under section 163A. The Apex Court, in case of Chandrakant Tiwari Supra, has held as per section 163A, it is a use of the motor vehicle as a case of accident alone which need to be established without any requirement to prove fault on the part of the driver, whether it to be owner or any other person. And also, as per that policy, the 50 rupees has been collected, additional 50 rupees has been collected as a PA cover, compulsory PA cover, bracket, owner driver. The tribunal has failed to consider this aspect of the matter. Under these circumstances, the matter requires to be remitted back to the tribunal for fresh consideration. Accordingly, the appeal is allowed. Judgment and award passed by the tribunal is set aside. The matter is remitted back to the tribunal for fresh consideration in accordance with law. All the contentions of the parties are left. No, it is 163A only. You have amended. Your petition is maintainable 163A only. It is correct. Earlier, your lawyer has filed 166. Then he has realized, filed an application 163A. That amendment has been allowed. Otherwise, your petition is not maintainable. 166 that has been treated as it has been treated as a 163A only. Yes, it has been amended, corrected as per the court order 1792. If it is 166, the finding of the tribunal is correct. 163A amendment ಮಾಡ್ಕೊಂಡು 166 ತರನ್ನ ಡಿಸ್ಪೋಸ್ ಮಾಡಿದ್ದಾರೆ. Yes.
Lord, I am for the respondent. This matter can be disposed of. I have
Yes.
already
Where is your friend?
Well, I have already discussed with Mr. Chandrasekharaya.
What
He
is
has
that?
agreed. My lord, ಇದು para 15 of the judgment, my lord.
Yes.
There are totally 5 injuries, out of which 4 simple injury and 1 grievous injury.
Yes.
My lord, tribunal has awarded 40,000. Then, my lord, it is only an open fracture of a tibia.
Yes.
Then, my lord, you ask me kindly, doctor has stated 32% disability to the limb and 16% to the whole body. But the tribunal has taken 10% to the whole body. Here, my lord, you ask me kindly, take the tribunal has taken income at rupees 10,000 per month. Accident is of the year 2017, 11,000 per month. My lord, 11,000 into 12 into 14 is age about 45 years, 14 multiplier, 10% ಬದಲು 11% multiplier ತಗೋಬೇಕು. If that is so, my lord, 1,84,800 will be the loss of future income. Para page 17, my lord, para 21. I'll give the breakup. My lord, regarding pain and suffering, my lord, another 10,000 may be awarded.
In addition, how much, Mr.?
ಅದು 89,000 plus interest ಬರುತ್ತೆ.
ಅಷ್ಟೇ, ಯಾಕೆಂದ್ರೆ we need not give all finding just because 10,000 rupees. Doctor evidence 1% ಜಾಸ್ತಿ ಮಾಡ್ಬಿಟ್ಟು you will get 1,68,000.
ಹೌದು.
1,68,000 1,80,000 ಏನೋ ಬರ್ತದೆ. ಒಂದು 10,000 ಜಾಸ್ತಿ.
ಹೌದು.
Give it as in a lump sum.
ಆಗ್ಬೋದು 1 lakh lump sum.
1 lakh lump sum without interest.
ಆಯ್ತು.
Without interest 1 lakh.
ಹೌದು.
ನೀವು ವಾಟ್ ಇಸ್ ದಟ್?
ನನ್ನ ಪ್ರಕಾರ 89,000 ಪ್ಲಸ್ ಇಂಟ್ರೆಸ್ಟ್ ಅಂತ ನಾವು, ಯಾಕೆಂದ್ರೆ ಅವ್ರು ತುಂಬಾ ಬಾರ್ಗೇನ್ ಮಾಡಿದ್ರು, ನಾನು ಸ್ವಲ್ಪ ಬಹಳ ಲಿಬರಲ್ ಆಗಿ ಕೊಟ್ಟಿದ್ದೀನಿ.
90,000 with interest.
ಆಗ್ಬೋದು.
Yes.
ಅಲ್ಲ, ಅದು ನಾನು ಅವ್ರಿಗೆ 1 lakh lump sum ಅಂತ ಹೇಳಿದ್ದೆ. ಆಯ್ತು, ಯು ಶುಡ್ ನಾಟ್ ಫೀಲ್ ಬ್ಯಾಡ್. ಅದಕ್ಕೋಸ್ಕರ ಈ ತರ ಬ್ರೇಕಪ್ ಹಾಕ್ಬಿಟ್ರೆ ಕರೆಕ್ಟ್ ಆಗಿ ಬಂದ್ಬಿಡುತ್ತೆ ಅಂತ ಅಷ್ಟೇ, ಏನಿಲ್ಲ, ಬಹಳ ಸಿಂಪಲ್ ಆಗಿದೆ.
No, that I will make it. That whether you are
90 plus interest ಬರುತ್ತೆ ಬಿಡಿ.
90 plus interest. Yes. So and so, learned counsel appearing for claimant has contended that at the time of the accident, the claimant was earning
15,000.
What is that amount? That is no discussion.
Yes, Manoj.
40,000 used for a pain and suffering.
ಮೇಸನ್ ಅಂತ ಹೇಳಿದ್ದಾರೆ 45 years.
I was earning 25,000 per month. The tribunal has considered the notional income of the claimant as 10,000 is on lower side. He further contended that due to that extent, the claimant has suffered grievous injury. He was inpatient for a period of
ಇದೊಂದು 20 days ಏನು ಹೇಳಿದ್ದಾರೆ.
20 days. He has suffered lot of pain during the treatment. He has examined the doctor. Doctor has assessed the disability of 32% right lower limb, 16% on whole body. The tribunal has assessed the whole body disability is 10% is on lower side. He further contended that due to that extent, the claimant has suffered grievous injury, was inpatient for a period of 20 days. He has suffered lot of pain during the treatment. He has to suffer this disability and unhappiness throughout his life. Hence, he sought for enhancement of compensation. Per contra, Shri D. Vijay Kumar, learned counsel appearing for the insurance company, has contended that even though the claimant has claimed that he was earning 25,000 per month, he has not produced any document to establish the same. Therefore, the tribunal has rightly assessed notional income of the claimants as 10,000 per month. He further contended that considering that evidence of doctor and considering that injury suffered by the claimant, the overall compensation awarded by the tribunal is just and reasonable. Hence, he sought for dismissal of the appeal. Heard the learned counsel for the parties, Feroz, judgment and award. It is not in dispute the claimant has suffered an injury in a road traffic accident occurred on 22/9/2017 due to rash and negligent driving of rider of motorcycle bearing registration number KA64 L6913. Due to that accident, the claimant has suffered the following injury. He has examined Dr. Ramesh B as PW2. In his evidence, he has deposed that the claimant has suffered permanent physical disability at 32% right lower limb, 16% to whole body. Considering that evidence of doctor, considering that injury suffered by the claimant, I am of the opinion the whole body disabilities can be assessed 11%.
11%.
Even though the claimant has claimed that he was earning 25,000 per month, he has not produced any document to establish the same. Therefore, the notional income has to be assessed as per the guidelines issued by Karnataka Legal Service Authority for the accident occurring 2017. The notional income has to be considered as 11,000. At the time of the accident, he was aged about 45 years. The multiplier applicable to the age group is 14. Accordingly, yes.
1,84,800.
2,03,000.
ಅಲ್ಲ 11,000 into 12 into 11%.
11%. Yes.
11%.
Correct.
Please, my lord.
Just one 2,03,000.
Please, my lord. ಅಲ್ಲ ಸ್ವಲ್ಪ ನಂದೇ
30,000 ಆಯ್ತು.
please, my lord.
Yes. 30,000 ಜಾಸ್ತಿ ಬರುತ್ತೆ. Due to that extent, the claimant has suffered the aforesaid injury He was inpatient for a period of 20 days. He has suffered lot of pain during the treatment. He has to suffer this disability and unhappiness throughout his life. Considering that evidence of doctor, considering that injury suffered by the claimant, I'm of the opinion that I'm inclined to enhance the pain and suffering ಎಷ್ಟು ಅಲ್ಲಿ
10,000 40 ಕೊಟ್ಟಿದ್ದಾರೆ 10,000 ಕೊಡಿ ಜಾಸ್ತಿ.
From 40 to 50.
Para 21 you will ask me kindly take up.
Then
my lord, loss of immunity is 20,000.
Loss of immunity is 20,000.
Loss of income during the period of treatment 33,000.
Loss of income treatment for 3 months 33,000.
That's all, my lord.
Yes, 30, 30, 60, 70, 89. 90,000.
Please, my lord.
Yes. Accordingly, the appeal is allowed. Judgment and allowed in part. Judgment and award passed by the tribunal.
Much best. Lord, I have filed wakalat, my lord, and office has not noted it. I don't know how.
Yes, where is that? Yes, D. Vijay Kumar is permitted to.
Hello, file wakalat agide 11/4/2022.
But
Here is the wakalat, my lord, comment.
ಅದು ಸುಮ್ಮನೆ ತೋರಿಸ್ತಾರೆ ಯಾವಾಗಲೂ ಒಂದ್ಸರಿ ಹಾಕಿದ್ದಾರೆ.
11/4/22 I have filed wakalat.
No, wakalat is not there, Mr. Vijay Kumar.
8657/19. My lord, see, you asked, I got acknowledgement.
Yes, Mr. No, it is not in the file.
Office to verify.
Yes, yes.
Put up first.
Yes.
Much obliged.
Shivakumar, can appear for the appellant. Release this matter after 3 weeks.
90,000 plus interest.
Okay. Yes. At the request of the parties, release this matter next week. Yes. Next week. At the request of R2, release this matter next week. Yes, Mr. Yes. Yes, if both of them sit together and said, I can modify. Yes. Yes. Thursday, next Thursday. Yes. Yes. Not the bandit. Yes. No. Otherwise, we can reduce that and you leave it. You can adjust ಮಾಡ್ಕೊಂಡು ಯಾವ್ದಿದೆ. See, 1 acre in 20. No, I will confine is only 1 acre 20 guntas. ನೀವು ಅದರಲ್ಲಿ 20 ಗುಂಟೆ ಯಾವ್ದಿದೆ ಅದನ್ನ ಅವ್ರಿಗೆ ಬಿಟ್ಟು ಕೊಟ್ಕೊಂಡ್ರೆ ಆಯ್ತು. ನೀವು you both make an understanding ಯಾವ್ದು 20 ಗುಂಟೆ ಬಿಡಬೇಕು ಅಂತ. I will say in that order reducing 1 acre 20 guntas. Then other new understanding ಮಾಡ್ಕೊಂಡು then is. Yes, that's instead of I can't say that boundary, I can say that before that you both have together and which 20 guntas has to be leave. Yes, yes, yes. At the request of parties, release this matter on Thursday. Yes, Suresh. No, is it? Where is that policy? No, you are just ಕೊಟ್ಟಿದ್ದಾರೆ 36,000. ಕೇಶವ ಪ್ರಶಾಂತ್ ಇಲ್ವಾ? Yes, 16 April 17. Accident ಆಗಿದೆ ಅವಾಗ. What is that vehicle number? Yes. Yes, Mr. ಅಲ್ಲ ಅವ್ರ ಓನರ್ಗೆ ಅದೇ your argument is supporting this case. Then insurance company, if we agreed, then its liability has to be fixed on the insurance company. No, but owner has not produced the policy before the tribunal. Now that he has producing the policy, if insurance company has verified, then we can change that liability on the insurance company. That's all. Where is Keshav Prasad? What is there? Keshav Prasad copy. No, he is happy that if this liability has been fixed on that insurance. He need
ಟ್ರಿಬ್ಯುನಲ್ ಅಲ್ಲಿ ಕೊಟ್ಬಿಟ್ಟಿದ್ರೆ ಈ ಪ್ರಾಬ್ಲಮ್ ಆಗ್ತಾರಲ್ಲ ಸೊ ಇವರು ಟ್ರಿಬ್ಯುನಲ್ ಅಲ್ಲಿ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿಲ್ಲ ಡೈರೆಕ್ಷನ್ ಕೊಟ್ಟಿದ್ದಾರೆ ಆಲ್ಸೋ ಓನರ್ ಅವರು ಪ್ರೊಡ್ಯೂಸ್ ದಿ ರಿಯಲ್ ಅಂಡ್ ದಿಸ್ ಪಾಲಿಸಿ.
Now that you have not paid 36,000, have you paid that amount? You have not paid. Then let us say you ask that Keshav Prasad will pass it out. Keshav Prasad idara karkavan BC Lilla, you just call him. Phone ಮಾಡಿ ಪಾಸ್ ಓವರ್ ಮಾಡಿದ್ದಾರೆ. We'll see, otherwise we'll close it. Yes.
48, Malad.
48. Yes, Aruna has taken time. Narayanam Nayak copy kotilva? Why, Mr. It is 2019. For permission to produce that additional evidence filed by the advocate for the appellant. What is that additional document? An additional document. Hospital bills. Hospital bills. Photo. ₹200. ಎಷ್ಟು ಹಾಕಿದ್ದೀರಾ ಅಡಿಷನಲ್ ಮಿಸ್ಟರ್? ₹2,500, 250, ಏನೊಂದು ₹5,000 ಹಾಕಿದ್ದೀರಾ. ಇನ್ಸ್ಟೆಡ್ ಆಫ್ ಸೆಂಡಿಂಗ್ ಬ್ಯಾಕ್ ಕ್ಯಾನ್ ಬಿ ಡಿಸ್ಪೋಸ್ ಆಫ್. ಟೋಟಲ್ ಎಷ್ಟು ಕೊಟ್ಟಿದ್ದಾರೆ? $1,74,000. ಅಲ್ಲ ಅದಕ್ಕೆ if he is not insisting will dispose of ₹25,000 ವಾಪಸ್ ಕಳಿಸಿದ್ರೆ ಅದಕ್ಕೆ ಜಾಸ್ತಿನೇ ಖರ್ಚಾಗುತ್ತೆ. ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅಲ್ಲಿ ವೆರಿಫೈ ಆಲ್ಸೋ ವೆರಿಫೈ. At the request of parties, release this matter next week.
I appear for the appellant in KSRTC, Malad.
Yes, what is this, Mr. Nath?
Malad, on the ground of negligence and quantum, Malad, I have challenged the judgment and award. The brief facts of the case is, Malad, on 22/8/2017, the accident has taken place between KSRTC bus and motorcycle. Malad, as per the police records, Malad, there is negligence. There is entire negligence on the part of the KSRTC bus. Therefore, Malad, I have produced additional documents showing that, Malad, there is no negligence. Even if there is negligence, some small, Malad, your lordship may kindly take, Malad.
What is this photograph shows, Mr.?
Yes, Malad. Photographs shows that, Malad, the accident has taken place towards when the bus was moving on the left side of the road. And the scooter, the motorcycle, it is on the middle of the road.
How can you say this photograph?
Malad, even the Malad, Samyukt Karnataka Malad people, they have also stated the first statement. Apagata.
All that cannot be considered, is it not? Then photographs has been taken
Yes.
after the accident.
But it is, but the photographs will be taken only after the accident. But what could be done?
When it has taken, see,
Yes.
there is no photographs where that bike and this thing both as this thing.
Yes, there are no photographs.
Photograph which is taken by that bus
Yes, there are no photographs. Malad, your last
related to the bike.
yes, but your last
That bike photograph has taken a separate.
yes, yes, Malad, it is true, Malad.
Then
Your lordship may kindly take Malad typed page number 6 of the judgment, para number 10. Issue number 1. Petitioner number 1 filed her affidavit in lieu of the examination in chiefs, stating that the accident occurred due to the rash and negligent driving of the offending vehicle by respondent number 1. Exhibit P1 to P8 are the certified copies of the complaint FIR Mahajar sketch. Malad, sketch may kindly be looked into because Malad, it is against to me. And the investigating officer, after detailed investigation, filed charge sheet against the respondent number 1, stating that the accident has occurred due to the rash and negligent driving of the bus. This is only for the purpose of assisting the court. The evidence of PW1 is corroborated these documents. Occurrence of the accident is not disputed. The death of deceased in the accident is not disputed. In the cross-examination of PW1, counsel for respondent number 2 suggested that the accident took place due to the negligence of the deceased himself, which is denied by PW1. The charge sheet is not challenged. It is not necessary. But look into the facts and circumstances of the case of the petitioner is there is no discussion.
No, why your driver has not given a complaint?
Complaint kodak hogirtare ella keslu hogirtare
That is not your evidence also. Then why you have not examined that driver?
Well, driver malad we have examined. Mithun RW1.
What he said?
Yes, malad.
Putting. Yes, Mr. Keshav Prasant is there. Monday, next Tuesday, next Wednesday. Yes. Wednesday. Yeah, yes. In the meantime, you get it verified. Our insurance company are I want to ask him to verify. What direct they will get it the instructor. We'll see that Wednesday. Yes.
In the appendix, it is stated that the PC Mithun RW1.
I will see why the tribunal has not discussed about his evidence.
Yes, it is even
RW1. No, Mister, you are not examined. It is wrongly shown. There is no such evidence.
Yes,
the original records.
Evidence records.
But he is a best witness. You are not examined. He has to say, first of all, he has not given complaint. He has not entered the witness box and saying that, yes, the vehicle was, bike was coming in the middle of the road. Then we have to see that version of the PW1 and the other police records. There is no other materials. Photographs cannot be seen at this stage. Is it not?
Yes, ma'am. PW1 is not the eyewitness. Is the
not eyewitness, but is
no eyewitness. No eyewitness has been examined on behalf of the
eyewitness has been examined. PW has spoken about that to disprove that
police records.
They have not. No, they have given evidence, and in support of that, they have given some police documents to disprove. You have not done anything.
Yes, madam.
That is that this thing.
Lordship, may kindly see this exhibit P4 ballot sketch supporting the contents of the Mahajar.
Yes.
Right, the bus was moving towards the Gundlupete. I think, Malad, your lordship.
Yes, yeah.
Yes.
That say you are
20 feet is the width of the road, and the bus.
east. You are moving from west to east.
Yes, my lord.
West to east, is it not?
Yes, my lord. As per police records.
Yes.
But now, my lord, I'll take your lordship's kind attention to the quantum of compensation awarded by the tribunal, my lord. I think, my lord.
Yes, what is that quantum?
Yes, my lord. Quantum, my lord, the tribunal has taken into consideration the salary of the alleged salary of the deceased. That is at 14,516, added 50% and deducted 1/4 towards personal expenses, multiplied by 12 into 16. That is because age of the deceased is 32 years. And the dependents are, my lord, wife, children, and parents.
Ujjwala Small Finance Bank.
Yes, they have not examined the author of the document.
What is that document? Exhibit P9.
Salary certificate, my lord, the computer generated salary certificate. Exhibit P9, my lord.
P9. Put it.
And he has worked only for not even 1 month, my lord, after resigning HDFC Bank. Even this HDFC Bank also, there are no documents. Only
bank name is HDFC.
Yes.
Employee number UGG. Now, where he is working? In HDFC.
Earlier he was working in HDFC. And later, my lord, he was working in Ujjivan Small Finance Bank. But I don't think, my lord, the Small Finance Bank will pay salary more than rupees 14,916. That is
no, this is if it is a registered, then we cannot dispute that, mister, because they are deducting that income tax also.
Right, Ujjivan Small Finance Bank, my lord.
No, even see, they are taking that PF and all. Then they cannot be give this false pay slip. But 50% cannot be taken because we don't know whether he's a permanent employee or on contract basis.
Yes, my lord.
40%, that has to be reduced to 40%. How many claimants are there?
My lord, claimants, my lord, there are 5 claimants are there, my lord.
Wife,
Yes, my lord. Wife, children, and parents, my lord.
Parents. 1/4 correct is there.
Yes, my lord.
Only thing is that it has to be reduced to 40%.
It is 40% only taken, my lord.
50 anta andralla.
Illa 40% tribunal has taken.
That's correct. Since
Yes.
this is hence 40% is to be added. Then it is correct, Mr. 15% ಕೊಟ್ಟಿದ್ದಾರೆ.
Yes, my lord.
ಇನ್ನ 40 ಕೊಟ್ಟಿದ್ದಾರೆ. 1 2 45 ಜನ ಇದ್ದಾರಾ?
ಹೌದು.
40 80 ಇನ್ನು 4 ಇನ್ನು 1.5 ಲಕ್ಷ ರೂಪಾಯಿ ಜಾಸ್ತಿ ಆಗ್ಬೇಕು. ಇಂಟ್ರೆಸ್ಟ್ ಎಷ್ಟು ಕೊಟ್ಟಿದ್ದಾರೆ?
6%.
Your case has to be dismissed and his case 1.5 lakhs has to be increased.
Yes, my lord. I leave to the honorable court, my lord.
Yes, where is he? He has no other thing except this because salary is there. Our appeal memo kodi Indian other ground is there. Entire salary has been taken.
Yes, my lord. Entire salary has been taken, but 200 rupees, my lord, professional fee has to be deducted. That is not there.
That correct. ಅದು ಮಾಡಿಲ್ವಾ?
ಮಾಡಿಲ್ಲ ಸುಮ್ಮನೆ
ಮಾಡಿದ್ದಾರೆ.
ಪ್ರಾವಿಡೆಂಟ್ ಫಂಡ್ ಮಾತ್ರನೇ.
ಬೇಸಿಕ್ 8,000, HRA 40, so cost of 8,000, total earning 13,000 ಇದೆ.
ಅಲ್ಲ, ಇದರಲ್ಲಿ ಒಂದು ಇದೇನಂತಂದ್ರೆ ಈ ಕಾಸ್ಟ್ ಆಫ್ ಲಿವಿಂಗ್ ಅಲೋಯನ್ಸ್ ಈಗಂತೂ ಮುಂದೆ ಅಂತೂ ಬರೋದೇ ಇಲ್ಲ ಅದು. cost of variable allowance, you know,
All that cannot be deducted, Supreme Court said,
yes,
except by income tax and professional tax.
yes, sir, professional tax has to be deducted, my lord.
₹200 ಡಿಡಕ್ಟ್ ಮಾಡ್ಬೇಕು ಇದ್ರಲ್ಲಿ.
ಹೌದು.
ಮಾಡಿಲ್ವಾ?
ಮಾಡಿಲ್ಲ ಸುಮ್ಮನೆ.
ಕಾಸ್ಟ್ ಆಫ್ ಲಿವಿಂಗ್ ಅಲಯನ್ಸಸ್ ಆಯ್ತು, ಟೋಟಲ್ ಅರ್ನಿಂಗ್ 13,000 ಸೊ PF ಪ್ರಾವಿಡೆಂಟ್ ಫಂಡ್ 1,000, ಮೊಬೈಲ್ ಡಿಡಕ್ಷನ್ಸ್ 4.
ಅದು ರಿಜಿಸ್ಟರ್ಡ್ ಕಂಪನಿ ಒಂದ್ ವೇಳೆ ಆಗಿತ್ತು ಅಂತಂದ್ರೆ ಪ್ರಾವಿಡೆಂಟ್ ಫಂಡ್ ಕಂಪಲ್ಸರಿ ಡಿಡಕ್ಟ್ ಮಾಡ್ಬೇಕಾಗಿತ್ತು, ತೋರಿಸ್ಬೇಕಾಗಿತ್ತು.
14,516 ಎಲ್ಲಿಂದ ಬಂತು?
14,516 ಇಲ್ಲಿ ಲಾಸ್ಟ್
ಇಲ್ಲಿದೆ, ಇಲ್ಲಿ ಕೆಳಗಡೆ
ಎಂಪ್ಲಾಯರ್ಸ್ ಪ್ರಾವಿಡೆಂಟ್ ಫಂಡ್ ಸೇರಿಸ್ಕೊಂಡ್ಬಿಟ್ಟು
ಅದರಲ್ಲಿ ₹200 has to be deducted.
ಎಸ್.
ವೇರ್ ಇಸ್ ಹಿ? ಅದು ಲೆಕ್ಕ ಹಾಕಿ. 14,516 200 ಹೋದ್ರೆ 14,316 ಪ್ಲಸ್ 40% ಪ್ಲಸ್ 40% to 1,4 deduction. $32 years,
ಹೌದು ಸ್ವಾಮಿ.
multiplier 16.
ಅಲ್ಲ 28,86,105.60.
ಒಂದು 75,000 ಜನ ಜಾಸ್ತಿ ಆಗುತ್ತೆ, 75,000-80,000 ಜಾಸ್ತಿ ಆಗುತ್ತೆ.
ಆಯ್ತು ಸ್ವಾಮಿ.
ಅದನ್ನ ಕಳೆದ್ರೆ ಅಲ್ಲ, ಕನ್ಸಾರ್ಸಿಯಂ ಅಲ್ಲಿ 5 ಜನ ಇದಾರೆ, 1 ಕೊಟ್ಟಿದ್ದಾರೆ, 4 ಜನಕ್ಕೆ 160, ₹5,00,000 ಜಾಸ್ತಿ ಆಗುತ್ತೆ. ಅದು ₹200 ಕಳೆದ್ರು.
ಆಯ್ತು.
ಎಲ್ಲಿ ಅವರು? ಎಲ್ರಿ ಅವ್ರಿಗೆ ಫೋನ್ ಮಾಡ್ರಿ, ಮಂಜುನಾಥ್
ಮಾಡ್ಬೋದು ಸ್ವಾಮಿ, ನಾನು ಅವ್ರಿಗೆ ಹೇಳ್ತೀನಿ, ಮಂಜುನಾಥ್ ಹೇಳ್ತೀನಿ.
ಫೋನ್ ಮಾಡಿ.
ಜಾಸ್ತಿ ಆಗ್ತಾ ಇದೆ ಹಿಂಗೂನು.
ಎಸ್, ನೀವೊಂದು ಫೋನ್ ಮಾಡಿ ಅವರಿಗೆ ಅಷ್ಟೇ. ಶ್ರೀ ನಾಗರಾಜ್ ಕೆ, ಲರ್ನೆಡ್ ಕೌನ್ಸಿಲ್, appearing for the corporation has contended that the accident is occurred due to the negligence of deceased himself, since he was riding that motorcycle middle of the road where there was no space left for driver of the bus to take any left side. Hence the accident has occurred. He further contended that the deceased was riding his motorcycle with a high speed, rash and negligent manner, even though there is a space left for his left. He came right side and dashed against that bus. He has contended that along with that application, he has produced that photograph to show that the deceased was riding that motorcycle in middle of the road. Hence, he contended that the accident is occurred due to the rash and negligent driving of rider of the deceased. In respect of quantum, he has contended that even though he has produced payslip and claiming that he was earning 14,516 per month, he has not examined that employer, and therefore the tribunal has to, instead of considering notional income as assessed, monthly income 14,516 is on higher side. He further contended that even assuming that the basics can be considered, in gross salary, there is no deduction for professional tax. Without deducting the same, the monthly income has been assessed by the tribunal Hence, he sought for a tribunal. Hence, he contended that the loss of dependency assessed by the tribunal is on higher side. He further contended that considering that age and avocation of the deceased, the overall compensation awarded by the tribunal is on higher side. Hence, he sought for allowing that appeal filed by the insurance corporation. Per contra, Manjunath Tendi, Learned Counsel appearing for the claimant has contended that the accident is occurred due to the rash and negligent driving of driver of the bus. Immediately after the accident, the police complaint has been lodged against the driver of the bus. The police, has registered an FIR against the driver of the bus and filed a charge sheet. He has not challenged the charge sheet filed against him. The insurance company has not examined any witnesses to disprove the case of the complaint. The tribunal, after considering FIR, spot measure and sketch and IMA report, has rightly held that driver of the bus is negligent in causing the accident. In respect of quantum, he has contended that the claimant was produced salary slip as Exhibit P9. His gross salary as 14,516. Considering the same, the tribunal has rightly assessed loss of dependency. He contended that in view of judgment of apex court in case of Magma, the claimants are entitled 40,000 each. Hence, he sought for enhancement of compensation. Heard the Learned Counsel for the parties. Peruse judgment and award. It is not in dispute, judgment and award. The case of the claimants that on 22/8/2017, at about 11:45 a.m., deceased Chandrasekhar S. proceeding along with Jagdish on a motorcycle bearing registration number KA09 ES 4085 from Gundalpete to Bomblapura village. When they are reached near Annur Kere Pond, Gundalpete Taluk, at the time, the driver of the bus bearing registration number KA11F 0394 came from opposite direction in rash and negligent manner, dashed that motorcycle. Due to impact, deceased Chandrasekhar has fell down, suffered injury, and succumbed to that injury. A standard of proof. The claimant through their case, first claimant has been examined as
TW1.
In her evidence, he has categorically stated that the claimant, the deceased was riding his motorcycle on left side of the road. The driver of the bus has coming from opposite direction, rash and negligent manner, dashed against that motorcycle. Due to impact, he fell down and suffered an injury and succumbed to that injury. Immediately after, they have filed a complaint against the driver of the bus as per Exhibit P1. The police has registered an FIR against the driver of the bus as per Exhibit P2 and drawn that sketch as Exhibit P4 and spot major as exhibit P3. The motor vehicle inspector has prepared an IME report as exhibit P5. The police, after thorough investigation, has filed a charge sheet as per exhibit P8. All these documents has been marked, has been produced to establish their case. To disprove the case of the claimant, the respondent has not examined any witnesses nor produced any documents. The driver of the bus is that best witness. The respondent has not examined the driver of the bus.
Basangauda Police Party.
Basangauda Police Party. By seeing that sketch exhibit, P4, it is very clear that the accident was occurred, the width of the road is 20 feet. The accident was occurred 4 feet from the road.
The road malad, wherein malad the motorcycle was coming.
From which place? What is that place?
Gundlupet.
Innanduru?
Gundlupet to malad.
Alankerena.
From Gundlupet to Bombalapura. Malad. It is in the
Gundlupet to Bombalapura, proceeding from east to west. The motor vehicle was proceeding from east to west. The driver of the bus was proceeding from west to east. The accident was occurred 2 feet from north.
16 feet from malad. 16 feet towards the right side of the road, in which
No, 16. From north 4 feet. From south 16 feet.
Yes, Parent.
That's what I said.
Yes.
From north 4 feet. Therefore, it is very clear that driver of the bus has crossed that median and went extreme right side, dashed against that motorcycle.
Additional
It is
document.
the sketch and Mazur and IME report. The driver of the bus is negligent in crossing the accident. The tribunal is justified in held that issue number 1 is affirmative.
Additional documents that I have produced. They are not supporting or
In respect of the additional documents produced by the corporation before this court, these are all photographs.
were taken after the accident.
This was taken after the accident. By seeing the photographs, it is not clear that the rider of the motorcycle was coming middle of the road and dashed against that bus. The tribunal, considering that documents available on records and the evidence of PW1, has rightly held that issue number 1 is affirmative. In respect of quantum, the contention before the contention. In respect of quantum, the claim of the claimant has claimed that deceased was working in a Ujwan small finance bank and he has produced salary certificate. The gross income as per exhibit P9, the gross salary is 14,516. In that, the tribunal has considered the monthly income of the deceased as 14,516. The tribunal has failed to deduct 200 rupees for professional tax. Hence, the monthly income has to be considered as 14,316 per month. The tribunal has rightly added 40% of the income of the deceased for personal expenses and rightly deducted 1/4 of the income of the deceased for loss of dependency. The multiplier applicable to that age group 32 is 16. Accordingly, loss of dependency has been reassessed as follows.
$28,86,105.
Yes.
And 40,000 rupees, 15.
In addition, 15,000 for loss of estate, 15,000 for funeral expenses.
By dependents.
In book of judgment of apex court in case of magma, the first claimant is entitled 40,000 for loss of consortium. Claimant number 2 and 3 is entitled 40,000 each for parental consortium. 4 and 5, 40,000 each for filial consortium. Out of that, 50,000 rupees interim compensation has to be deducted.
Yes.
Yes. Remaining with 6% is directed to be deposited. Amount in deposit is transferred to the tribunal.
Please.
$31 lakh 16,140.
Out of that, 50,000 rupees has to be deducted.
31 lakhs 16,000.
Sir. 31 lakhs 16,144.
Please.
Yes. Which one? 4 and 5? These two. Yes. That we will file it in that office. We'll dispense when it is posted. Strike with.